legal fraternity, if you look at it, we have the Chief Justice of India who has passed out from this college. That is Justice K.G. Balakrishnan. Then we have a long list of judges who have come out of this college. I understand there are at least 16 judges who have passed out of this college, and I think Justice Rahim that's one batch which had 6 sitting judges at one point of time. That is Justice Rahim's batch. Even today we have around, I think, about more than 6 judges on the bench. So that is the kind of 10 at the moment. So that is the kind of legacy that that this college has, that this institution has, and we wanted to celebrate this occasion. And for that, when we were looking for a speaker, for someone who could do justice to a great topic, we approached Justice K.M. Joseph sir, and immediately the first name he said was of Justice Chelameswar. We are so happy that Justice Chelameswar is with us. Justice Chelameswar, who was the Chief Justice of Kerala in the year 2010-2011. He is born in a village that is in Mova Mandal in Krishna district in 1953. Finished his BSc Physics from Loyola College, Chennai. Then did his law from Visakhapatnam and became a judge in Andhra Pradesh in 1997. And there are several decisions to his credit, but I would not like to keep you away from the topic of today, that is whether secularism and socialism, whether that has to be done away with, because there is a clamor for doing away. There are 2 schools, and what they say and what it is, all will be spoken about by Justice Chelameswar. But I just take this opportunity to inform of 2 things. That is, one relating to the alumni. That is why I thought I'll say that. The government of Kerala is organizing an alumni conclave on the 30th of August in Trivandrum. And the colleges and the alumni have been asked to send representatives to this conclave. This is the first time that such an event is taking place in Kerala. I'm not sure whether there was anything like this done before this. The idea is to come up with the alumni and the institutions coming together on a platform, and then for the development of the colleges. So that is one thing that I would like to point out. I think Justice the Grace teacher has come. Thank you, teacher. May I request Justice K.M. Joseph to honor Grace teacher, one of our senior most teachers who has taught us. Thank you so much, teacher. May I now invite Justice K.M. Joseph, who is presiding over this function, who's been a chairman. He's the chairman of the lecture series that this alumni is organizing. Today we are having the first of the lectures, and then we'll have a series of it, and then we propose to have a valedictory function towards the end of this year. May I request Justice K.M. Joseph to kindly deliver the presidential address.
Justice Chelameswar, teachers of the law, members of the Alumni Association, and all those who have gathered here, and of course students undergoing the LLB, LLM courses in this college. It's something of an emotional moment for me. I remember, many of the benches on which I have sat 43 years ago. third year, and many of the things which happened in this classroom, many of them are unmentionable for this auspicious occasion. So I omit them, but then glorious days. This is an institution which was established in 1876 by the Maharaja of Travancore. The enlightenment which allowed them to harbor the great vision that led them to establish one of the oldest law colleges, as it turned out later on. And my pranams to them for what they have done. And that's why we are here to begin with. Then about Justice Chelameswar, when Sanjay and Hari came and we were planning, and I suggested Justice Chelameswar's name, and we were sitting in my office, and then we made a phone call, and Justice Chelameswar readily, without any hesitation, agreed to come. So yesterday night, in the course of a private conversation I had with him, he mentioned the true reason why he agreed. He said, when any educational institution calls him for any function of this nature, he has never refused. And why is that? There is a rationale. He says that it is in the colleges that you find the future of India, the young blood, into whom you have to inject streams of pure knowledge to ignite their minds, which is why he never turns down, whatever be the difficulties, he never turns down. I mean, hats off to you, sir, for having that kind of an approach, which is why you are here. And many thanks for taking the trouble of, in the midst of your very busy schedule, to come here and be with us. Then about the topic, a few words I thought I could venture. The clamor for removal of secularism and socialism from our preamble. It is true that the 42nd Amendment, which came into effect on 3/1/1977, that the word secularism and socialism was added to the preamble by the 42nd Amendment. As regards the question of secularism is concerned, it is worthwhile to consider what would be the effect if you did formally remove the word secularism from the preamble. Kindly consider what would happen. We would still have Articles 14, 15 and 16, which form the trinity of the equality code we have in the Constitution. Article 15, for instance, forbids the state from discriminating against anyone on the ground of religion only. Article 19 gives fundamental right to freedom, various freedom, the freedom of expression, freedom to move and reside in any part of the country. All those freedoms which you're all well aware, I do not, they are made fundamental rights. Article 21, which has received so much of proactive judicial consideration, particularly the hands of the Supreme Court, leading to the unraveling of so many unenumerated rights, as they're called. It speaks about the right to be not deprived, fundamental right not to be deprived of your life and personal liberty except in accordance with the procedure established by law. Then you have the religious freedoms themselves embedded in the Constitution in the form of Articles 25 to 30. Article 25 in particular, subject to morality and so on and so forth. Every person, not citizen alone, has the fundamental right to practice, profess a religion of his choice. It also is a right available to an agnostic, an atheist, a believer, non-believer too, because it is a basic of all freedoms, declared in all the fundamental documents all over the world. Would the question that I would be posing is, and I'm sure Jasti Chelameswar will go into it at greater length, even if you were to remove the word secularism from the preamble, what good will it do? Will it achieve the purpose of anyone who is trying to play mischief with the body polity? The real problem is, because this question as to secularism, as to what is the meaning of secularism, first engaged the attention of the Supreme Court in the decision relating to under Article 30, where the view taken was what secularism, what actually secularism means is to live and to allow others to live, to tolerate others. That is one view. Justice Khanna, in fact, took the view that it means adopting an attitude of equality towards all religions. And later on, the fundamental rights which I have mentioned in the Constitution, which relate to right to equality, freedom, none of this can be tampered with by the state, even if you were to take out the word secularism from the Constitution, from the preamble. The real problem, according to me, is the fact that politicians make use of religion. Religion per se does not really create any problem. In fact, the Hindu religion, which is practiced, professed by 81% and odd of the population, is the most tolerant religion that is accepted in the world. If of late we are seeing a different phase, the problem lies at the doorstep of the politicians who are making use of it. And much of case law from the Supreme Court has arisen under the Representation of People's Act, where speeches are made by politicians. Religion is used for the purpose of actually gaining power. This is where I think the problem lies as far as secularism goes. So my view is that if somebody tries to remove it, it really is intended to create mischief, because India is a secular country under the Constitution otherwise. Coming to socialism, again it was slipped in by the 42nd Amendment. Now, there are different shades of meaning to the word secularism. Around 65 interpretations of the word socialism exists in literature. The most commonly understood meaning of the word socialist is state ownership of the means of production. This is actually the communist Karl Marx understanding of ultimate power through revolution to seize the power and to nationalize and own and control the means of production so that it can be used for the better good of the society. But there are other meanings also attributed to the word socialism. Now, here my point is this. If you look at the Indian Constitution, you have Chapter 3, which deals with fundamental rights. It is actually traceable to the International Covenant on Civil and Political Rights, which, as you know, India is ratified in 1976, though it came into force in 1966. India is a party to it. Equally, there is an international covenant in 1966, which deals with educational social rights. The Indian Constitution actually enshrines the civil and political rights part particularly in the chapter relating to fundamental rights. But part 4 of the Constitution dealing with directive principles are relatable to the second generation of what we call human rights, second generation, which deals with social economic rights. The Supreme Court, by a process of creative interpretation, has actually married these provisions at very critical juncture of our history to produce a variety of rights. Take, for example, the birth of the right to education in Unnikrishnan versus State of Andhra Pradesh. Now, this was achieved by the Supreme Court by looking into Article 21 and also looking into Articles 41 and 45, which are directive principles which speak about the duty of the state to actually provide education. And finally, after about 15 years or so, you have Article 21A, under which you have right to education as a fundamental right itself, up to the age of 14, between 6 and 14. So actually this has been going on, this, the interpretation involving an enforceable part of the Constitution, Part 3, and the non-enforceable part, by having this creative approach. Now coming to socialism, if you look at the provisions of the directive principles, you take for example Article 38.2. 38.2 exhorts the state to do what it can do in its might to minimize inequality and to eliminate the inequality of status and things like that. Article 39B speaks about the material resources of the state being duty to use it for the common good of the man, a provision which has generated so much of litigation. So if you go through the whole of the chapter on directive principles, if you compare this, for example, with the American Constitution, which is a very brief constitution, as you know, or if you look at, Britain doesn't have a written constitution, you look at the working of many of the Western economies which are said to be capitalist. You will find one common golden thread running through all this. After the revolution which was actually propagated by Karl Marx, there was a scare which was actually spread throughout Europe. And Europe, in England, for instance, it started on a socialist agenda, particularly with Sidney Weber and Bernard Shaw and the socialists of that era. And they brought in a lot of legislation on their own, which was actually attempting to make the state a welfare state. America does not profess, there is nothing in the Constitution which is comparable with Part 4 of the Indian Constitution. It is a laissez-faire constitution. It is Adam Smith's, that government is with best which governs the least. Leaving parties to form contracts, to work out their rights, to do whatever they please, government should not interfere. Indian Constitution is different because we have a different social milieu. We had a different background. We had a colonial past. We were actually so poor at the beginning of the Constitution that, if I may just compare Article 38.2 in its operation in 1951 and what it's happened with reference to statistics. The World Inequality Lab has come out with some startling, shocking statistics. In 1951, actually 1% of the Indian population earned about 11% of the national income. The height of the socialist era, Mrs. Gandhi, particularly closer to the USSR, and we were actually having this 5-year plans and everything was borrowed from there. The 1% was started earning only 6%. There was a decline in the share of the national income. What is the position today after the so-called integration after the 91 reforms? Today, 1% of the Indian population earns 22.6% of the national income. 1% earns 22.6%. 1% of the Indian population, the super rich, control 40.5% of the wealth of the country. Now, what does the bottom 50 earn? They earn close to 15,000 rupees per month. It's about 74,000. It is the gross national income. I mean, their income. Now, the inequality has grown despite the injunction in Article 38.2 that the state should do must strive to minimize inequality, because inequality cannot be done away with. The founders of our constitution very well knew that it cannot be done away with. But attempts should have to be done to minimize it. But the direction that the Indian economy is taken is to produce nearly 200 billionaires. We are number 3 in the number of billionaires that a nation has. After the United States and China, India has the largest number of billionaires. But we have 3.44 crores of our Indian brothers and sisters living in what's called extreme poverty, which means they are earning less than $2 in a day. The fate of the vast majority of our people, after 75 years of rule under the Constitution, and after Mrs. Gandhi, under the leadership of Mrs. Gandhi, they slipped in the word socialist, is that our condition is bad. Now, take for example the transition from the monopolies restrictive trade practices regime to the Competition Act. It clearly, actually, you see, you are witnessing a shift in the economic model which our government and the people through the government want to achieve, which is that we want to become the country with the largest absolute GDP. For instance, we are close to, we are about number 3 or 4, we are saying we are having it. But what is the per capita distribution of our gross product? The gross product can be an astounding sum, but this is a contribution of a few. Plus, we are the largest, we have the largest population, which means that we will naturally have a larger GDP. It is just some numerical strength that you're having. But how do you divide the cake, the national cake of gross product equitably among the members? That is what really matters. We are supposed to have overtaken Japan, but in actual terms, we are far behind the other countries. So here it is that the concept of socialism assumes importance. And my point is that even if you were to delete the word socialist from the Indian Constitution, unlike other constitutions, as long as we continue to have the chapter on directive principles, no state, either at the center or at the level of the states, can actually wander away from the socialist path if socialist path is not to be confined to the communist model. We do not have the communist model in the Constitution because Article 19 gives everyone the fundamental right to pursue a vocation, to carry on a business. What was contemplated is a mixed economy. The fact that we are actually slowly, allowing the public sector to shrivel up, thinking that they should not have such a huge role, is a different thing. But the fact remains that our economy contemplates a role for both the state and the private sector. What is the proportion, what should be the relationship is a matter for the government of the day. But I would therefore argue that if there is an idea to remove the word socialist, it would be at the risk of further diluting the goals which are actually enshrined in Part 4 of the Constitution dealing with directive principles. With these few words, and I know that you're waiting to listen to Justice Chelameswar, I wish you all the best, and I thank the office bearers for having given me this opportunity. Thank you. Jai Hind.
May I now invite the chief guest speaker of the day to start the lecture.
Members of the teaching faculty present and past of the Maharaja College of Law, Ernakulam, our government law college today, students present and past, and the supporting staff of the college, my very dear brother Joseph, who's already included in the former students category, but nonetheless, he was instrumental for my being here today. Ladies and gentlemen, a very good morning to, well, it's almost afternoon, midday. Customarily, we say it good morning. I hope I'm audible. Yes. Now, in fact, my brother Joseph has said it all. He didn't leave me anything to speak about. But nonetheless, having accepted the invitation and hospitality, I'm still supposed to speak. So I'll recycle whatever he said into different language slightly and then put it to you. The topic, as you know, is clamor for dropping of the two words socialism and secularism and socialism from the preamble. At the outset, a few days back, I saw in the newspapers one of the union ministers made a statement saying that there is no such proposal before the government of India. Well, so therefore, maybe perhaps this topic itself was chosen at a point of time before this statement was made by the Honorable Minister. But nonetheless, it generated some amount of debate in this country whether these words should remain there, do not remain there. And also, we know from history, so nothing is eternal in the universe, and more particularly in political arena. Statements made today can comfortably be forgotten tomorrow. So therefore, that perhaps if the idea once generated, somebody sparked up the idea, well, we don't know what may happen at a future date, but right now that doesn't appear to be a threat. Question is not whether these words remain in the preamble or not. For about some 25 or 26 years after the formation of the Republic, these two words did not exist in the Constitution. They were introduced by a constitutional amendment, if subject to correction, it's the 42nd Amendment, right? Was it? 42nd, yeah. 42nd Amendment. Before the 42nd Amendment, these two words did not exist in the preamble. But as rightly pointed out by my brother, even without that, parts of the Constitution dealt with these aspects of the matter. I'll come to it a little later, how it all happened. Technically speaking, what could be brought in by an amendment could be deleted by an amendment. There shouldn't be any difficulty. I remember long back that great jurist which in this country produced in the 20th century, late Mr. Palkhiwala, who inspired a lot of people in my generation. He said, whatever is licit is not necessarily right. That's a beautiful statement he made. What is legally permissible? Well, it's possible. If you could amend it in the 42nd Amendment, by another amendment it can be dropped. Because we see almost every political party, every politician in this country pays a tremendous lip service to Baba Saheb Ambedkar. And people claim that he is the one who gave the Constitution to this country. His contribution is extraordinary in the making of the Constitution. I have no second opinion about it. But don't take me wrong, if he created such a wonderful document, why did it require 130 amendments so far in the last 75 years, average of 2 amendments every year? Either there's something wrong with the idea of Baba Saheb, or there's something wrong with us, we are not able to work that constitution. Whichever is right, it's up to you to determine. I make it very clear. It was a great mind. If anybody goes through his speeches in the Constituent Assembly, don't even have to go through the whole thing. Just the last speech he made on the concluding session, he said certain things. One is, now we have going to have a republic, a constitution. There are legally permissible way of securing redressal for the grievances. This grammar of political anarchy must be stopped. Unfortunately, we never listened to him. The political anarchy continued. Second thing, more importantly, he said, don't surrender your liberties at the feet of even a great man. Retain your liberty always. The other man may be great, whoever it is. But each one of us, we talk about equality before law under the Constitution. Greatness by virtue of certain deeds and practices and contribution to the society, greatness is achieved. But nonetheless, every human being has its own dignity. Let it not be surrendered at the feet of somebody because he is great. Respect the great man. But that does not necessarily mean surrendering before him. You can always disagree with the thing. Anyway, point is, he was the principal architect of the Constitution. Now, as I mentioned, question is not whether these two words exist in the preamble or not. That's not very relevant. As I told you, they can be dropped if really the Parliament decides to do. The whole trouble is this. Constitution, any constitution in a democratic society, in any country, is an ongoing debate eternally. There's nothing sort of petrified about the Constitution. Any constitution in any republic requires adaptation for the changing times and changing requirements. There is no difficulty about it. The question is, what is the requirement to change is the more important question. Do we need to change these two concepts? Do we give up? As pointed out by Brother Joseph, even without these two words, if you look at the Constitution and its structure, the principles underlying socialism and secularism have been there in the Constitution from the day one it was enacted. And they didn't happen overnight. It didn't fall from the skies. It's not that Baba Saheb or Jawaharlal Nehru or Gandhiji received a vision from heavens like Moses received it on the, what is it, Mount Sinai, brother? Mount Sinai. It was an ongoing debate. It all started post 1931, 29 to be more precise, and 31 is the second. 1929, the Congress party had a session in Karachi. I am not talking about Congress party today, XYZ leaders, I am not at all on that. Congress party as it existed, which participated in the freedom struggle. Of course, nowadays there are questions whether they participated or somebody else got his freedom is a different debate going on in the country. Let's not go into it. The Karachi session, Jawaharlal Nehru introduced a resolution. And mind you, that session was presided over by a gentleman for whom a huge, some 100-feet statue is erected recently in Gujarat, Vallabhbhai Patel. He was the president of that session. It is not that small people like us were there. It was in that Karachi session, Jawaharlal Nehru first introduced the a resolution. And I think it's useful to recollect it, because nowadays we tend to forget everything and try to rewrite our own history the way which we like. The resolution read something like this. The Congress, therefore, there is a background to this. There was a Brussels, please come. There was a Brussels convention before that of the colonial countries. A lot of things happened. Nehru participated in that, and then on the 10th anniversary of the Russian Revolution, both Motilal Nehru and Jawaharlal Nehru were there. Mind you, I am not sort of carrying on any propaganda for Congress party. I am only recollecting history. That's what happened. Now, these ideas were picked up. And in the Karachi resolution, the language is this. I'll just read out a few clauses. I'll not read the whole thing, runs to about a page and a half. The Congress therefore declares that any constitution which may be agreed to on its behalf should provide to enable the Swaraj government to provide for the following. Every citizen of India has a right of free expression, right of free association, right to assemble peacefully and without arms for the purpose not opposed to law or morality. Compare your Article 19, which eventually got its way into 19. Every citizen shall enjoy freedom of conscience and the right freely to profess, practice his religion subject to the public order and morality. I suppose that's what normally we mean by secularism. 3. All citizens are equal before law. Then it is all about freedom, liberty and conscience and religion, secularism. I am not reading the whole resolution. Now, other aspect is the state shall own or control key industries and services, mineral resources, railways, waterways, shipping and other means of public transport. Mind you, by 1929, air transport was not a very prominent thing. It just was starting all over the world. So they didn't include. Railways and shipping were more important modes of transport. This was the resolution introduced in Karachi session. Then of course it was reiterated later in Lucknow and so on and so forth. That's not the point. There is a background, there is an evolution. These are the ideas. Why was it? India was a country with enormous amount of poverty. And it becomes the burden of any sensitive man who is aspiring to play a role in public life to look at that problem. Securing power is not for just enjoying it. If a person is really sensitive about public needs, he is serious about when he is talking about serving the people, the first thing such a person should be sensitive to is poverty and suffering of the people around. The kind of poverty which India was facing on that day, we can only imagine, we have not seen. Thanks to various factors, including the development of science, some amount of planning by the government, by various government, Delhi, Ernakulam, Hyderabad, Madras, wherever it is. We don't see that kind of poverty in India today. Millions of people perished in famines year after year in this country. Perhaps the last major famine was the famine of Bengal sometime in 50s. Before that, it was a regular feature in this country. I know my own home state, Andhra Pradesh, from 1775 to 1835, 4 famines occurred in the present state of Andhra Pradesh before Arthur Cotton built those 2 projects on Krishna and Godavari. Thanks to him, Afterwards, those districts never faced that poverty. Millions of people perished. Millions. You can check up online, the information is available. So when people of that, and these resolutions were supported by the freedom movement, Gandhiji, whom we respect as the leader, the father of the nation, all of them put their minds together. In fact, before the resolution was introduced, number of drafts were made. Gandhiji, until Gandhiji finally agreed for the resolution, in the sense the language meticulously checked up every word, every punctuation. The poverty was a concern. Just as Joseph was mentioning, American Constitution has no reference to these things like it's based on laissez-faire state. The reason is very obvious. It's a vast country with a limited number of population when the Constitution was there. Even today, the population is about 35 crores, almost 1/5 of Indian population today. And the land mass is 5 times more than the Indian land mass. So this kind of poverty, man-made poverty would be there. There will be billionaires. And they are not very affluent people in America. With this kind of abject poverty, it's not possible in United States. It's possible in India. It's possible in many other parts of the world. It was possible. It was a fact in Russia that led to the revolution. So when I opened my speech saying that Constitution is a continuous process, it's not something which falls from heaven overnight. It comes out of experience of life. If I am not misunderstood as boasting about my own work, just to drive home the logic, in one of my judgments, I said it. Don't read the Constitution as a document written on paper with ink. Please read it as a document written in the blood of the martyrs of Jallianwala Bagh. Then you will understand the document, what exactly it wants to convey. Otherwise, it's like any other enactment, any other law. You read it, the grammar, the syntax, blah, blah, blah. And then that can be changed. But there are profound factors behind these things when we frame the Constitution. Centuries of experience, homegrown experience gained from observing the humanity, other countries, other parts of the world, all these things. Now, Indian Constitution speaks about equality. Today, equality is so-and-so, employment, most of the time we fight about getting jobs or getting a seat, therefore Article 14. So, point is not that. What kind of a social system did we have before 1950? Equality, were all sections of people treated equally in India? No, even in America they were not treated equally. Colored people had great discrimination. Till 1960, 62, 60, let us say 52 was Brown versus Board of Education. The colored people in America had separate schools, separate restaurants, separate beaches, everything was separate. It's not that it only happens, human nature is the same wherever in the world. Names change. Maybe in India there is one name, or in Kerala one name, and Andhra another name, America a different name. But human nature is the same. People always try to individuals try to assert their superiority over fellow human beings. Whether they are really superior or not is a different matter. Physical strength, economic strength, and these are factors which enable people to assert their superiority. And necessarily it leads to oppression, unwarranted exploitation of fellow human beings. Now, when a constitution was being prepared, these are all factors which went into the minds of those great minds who sat in the Constituent Assembly. They were all experienced people. They knew history. Not that every one of them was a historian. They had a vast experience in life. And more than anything else, I believe, quite a large number of the members of the Constituent Assembly were willing to learn from somebody who is more learned than them. Our problem today is none of us is willing to acknowledge the greatness of another man and the knowledge of another man. All of us believe that we know everything under the sun. Afterwards, no further debate is possible, no democracy is possible. These factors went into the making of the Constitution. Then, when the Constitution itself came to be drafted, the Constituent Assembly debates, this Karachi resolution and the various aspects of the Karachi resolution were widely debated in the Constituent Assembly. And the Constituent Assembly agreed. First, when we talk about secularism in this country, the secularism in the context of America is different. Though they don't use the word secularism, the separation of church and state, that state shall not meddle with the religion or religion should not be imposed, that's a different matter. In the Indian context, secularism has different background. This nation, this country, this territory is home for innumerable religious practices and denominations. It's unfortunate today that when we talk about secularism, we talk about 2 or 3 religious denominations. Especially the youngsters. I don't know how many of us still remember, youngsters or older people, there was a phase in Indian history where Vaishnavites and Shaivites fought bloodbaths. There were exterminations. The great spiritual leader of Vaishnavism, Ramanuja, had to, virtually it was an exodus from Tamil Nadu to present-day Karnataka, Melkote. The Cholas were Shaivites. They didn't tolerate a new doctrine. And there was a huge persecution. At the age of 90, and Ramanuja is recorded to have lived for 120 years, long life he had. At the age of 95, the man undertook an exodus from Tamil Nadu to Karnataka because the Balals of Dwarasamudra, present-day Halebeedu, they were more willing to accept the new doctrine. So he found a safe haven there. He migrated to Melkote. So secularism is not something about Hindu, Muslim or Christian or something like that. It's true of not only this country. Take the history of Christianity. What was America? Why did people go to America? Not able to stand the persecution in Europe by certain groups. Those who were not willing to be obedient to the established church, they went in search of freedom, particularly religious freedom. So it's a human problem all over the world, all the time, which is now metamorphosed into political persecution. You belong to my political party, you are always right. If you don't belong to my political party, whatever you do is wrong. That's what happens in this country right now, or anywhere in the world, that's what happens. What's happening in United States, what's happening in India, it's part of human nature. Just to guard against these kind of practices, this kind of a thing, to establish a more civilized, humane society, constitutions are prepared. And when the Indian Constitution was prepared, the framers of the Constitution, members of the the Constituent Assembly, were broadly aware of the innumerable practices and differences in this country. They had to be synthesized to create a hope. And then we know the Indian history. Even as on the date of the preparation of the Constitution, only 2/3 of what we call India today was under the British rule. 1/3 of the territory was still under the hands of various Rajas, Maharajas, some 550 of them. And the laws varied from place to place, practices varied from place to place, the social conditions varied from place to place, the economic situation was not uniform. Now, if you are creating a new nation as a one political entity, India was culturally perhaps one throughout ages. There are a lot of common factors all over the country, cultural practices. But as a political entity, the entire India as we know it today was never a single unit. Most, at the best, during the period of Ashoka, substantial portion of present India was one political entity. Whatever political, this kind of communication systems were not there. Namesake, there was an emperor of India, Ashoka. What kind of control he exercised over Andhra Pradesh or Maharashtra, God alone knows, it requires a huge study. That was one phase. Second, nowadays a very, a personality who the mention of whose name itself is creating problems is Aurangzeb. For good or bad, during his period up to Kaveri, it brought under one. How wisely he ruled is a different question. I am not going into it. It's a statement of fact, political fact. Beyond that, at no point of time, India existed as a single political entity. Every 10-15 kilometers, there was a Maharaja. Well, and then that's also not permanent. It kept on varying from every 20 years, 30 years. The boundaries of the so-called territories changed. And I'm sure, of course, I'm not, unfortunately, not at all acquainted with Malayalam literature. But I can guess, knowing the Indian mind, all those petty Maharajas I know in my Telugu language, my literature. A fellow who ruled maybe a territory which is equivalent to 2 or 3 districts in present context is described in literature as a man who ruled the whole earth, covered by the 4 seas on 4 sides. I am sure this kind of description must be there in Malayalam literature also. It must be there. It is part of Indian system. Now, point is, with this many variations, for the first time an experiment was undertaken to create one political entity of these huge variable factors. And knowing human nature, and in the light of the experience immediately before the coming into the existence of the Republic, the division of the subcontinent into 2 states purely on religious basis, the existence of huge segments of population belonging to various denominations, some arrangement had to be made to assure each one of them, both minority and majority, that state will not interfere with these matters, your religion, your faith, your conscience. That's why a specific article is introduced, a specific chapter about religious freedom, 25 to 30, which included the minorities also. 25 to 30 do not deal only with minorities, it deals with religious freedom. Every person shall have freedom of religion, conscience, to preach, practice and propagate his religion. These are all factors which went into the making of the Constitution. Now, what great wisdom prompted the members of the Parliament when they made the 42nd Amendment in introducing 2 words in the what is not, if the for your information, Indian Constitution is perhaps the longest constitution in the world as on today, with some 395 articles and 11 schedules, 130 amendments, so on and so forth. If that big document could not convince people that it is a secular and socialist structure, adding 2 more words, I don't know what is the wisdom. Anyway, they did it. I remember when this word socialism was introduced. Sorry, Mr. Rajiv, don't get offended. Brother Joseph was mentioning 74 and, well, like the modern day, whatever political sloganeering, it is always there in politics. Sloganeering is part of politics always. Socialism was a slogan those days. Everybody was a socialist, starting from the highest office to the last office, including judges, Supreme Court, High Court. And once again, late Mr. Palkriwala used to deliver an annual lecture every year after the budget was introduced in the parliament. It all started in the Shanmugananda Hall of Bombay, a budget analysis. Later, of course, the crowd swelled and it was moved to an open, I think, Shivaji Maidan or something like that. It started with Shanmugananda Hall. 74, I think, I was in the law college. He opened the speech. These speeches are collected and published in the form of a book titled We the People. If some of you, if anybody has seen that book, otherwise kindly read it. 74, he opened the speech. Socialism in this country means many things to many people. And for some, it simply means a berth in the Union Cabinet, he said. So that was the order of the day. Maybe I'll add, maybe in the Supreme Court, a seat in the Supreme Court also. Quite a large number of judges those days were talking about socialism at various levels, various courts. The point is, it is all sloganeering. Are we really? Now, socialism, no doctrine is perfect. No doctrine. Either socialistic doctrine or Hindu religion or Islam or whatever is the doctrine, everything would have, whether there is something wrong inherently with the precept or the problems came with practice is a different matter. We have to see it later. I'll tell you an anecdote. I was not present. Somebody who was present in the court those days told me. When people were talking about socialism, everybody was a socialist. That famous case, which came from, incidentally, from Kerala, Keshavananda Bharati versus State of Kerala. The matter was being argued in the Supreme Court. And the argument was led by late Mr. Palkriwala. It went on for some 54, 55 days exactly, I don't remember, 54 or 55. It went on arguments. After 3-4 days of argument, one of my illustrious predecessors, some 2 generations before, Honorable Judge of the Supreme Court, was a little peeved by Ms. Palkriwala's argument about fundamental right to property. And then it appears the judge was a little impatient and gave a 5-minute, interrupted the counsel, Palkriwala, gave a short speech about 5 minutes about the greatness of socialism and the dirt of the right of property, and so on and so forth. And so Palkriwala was a very intense listener, apart from being a scholar. I had the good fortune of meeting him 2-3 times. Very intense listener. When somebody is speaking, you would pay full attention to He heard the judge very intensely. And after the judge stopped, I believe he said, "May I respond, my lord?" The judge said, "Yes, Ms. Palkriwala." It appears, he said, I was not present. Somebody who was present in the court told me later. I believe he said, "My lords, we read newspapers, people trying to cross the Berlin Wall and getting shot dead from East Germany to West Germany, people trying to escape this thing and getting shot and dead." And he gave a long pause, a very dramatic pause, and told the court, "Not even a lunatic ever attempted it the other way around," he said. This has nothing to do with the theory of socialism. In practice, what happened? Why did the Berlin Wall collapse? It's a fact today. We have seen 1990, the Berlin Wall. Point is, any dictatorial tendency, any regime, whatever name you give it, give it socialism, fascism, nationalism, whatever name you want to give it. But if it starts interfering too much with the liberties of the people, their lives of the people, the regimes don't survive. The theory would, there may be nothing wrong with the theory, but in practice, things go wrong, things collapse. See, people talk about socialism, and of course today the conflict of religious practices. am not aware of any religion which permits speaking of falsehood. क्या साहब? Islam में, is it possible? I don't think Islam approves it. Christianity, Christ never permitted it. The height of Hinduism, it never. But then Christians, Hindus, Muslims, everybody speak lies and falsehood as a practice. But in theory, none of these religions. Similarly, when you talk about socialistic this thing, every religion says, please look after the weak and poor in your neighborhood. There is no religion which justifies in theory amassing wealth and depriving others. In fact, I remember late Mr. Radhakrishnan wrote a book. He wrote many books in which he says there are 6 major religions in the world. He said Christianity, Islam, Buddhism, Hinduism, Zoroastrianism, and 6th communism, he said. You see, it has all the traits of a religion. It has its gospels, it has its preachers. Ultimately, what is a religion? A set of norms. One thing is, the communist theory does not believe, does not at least profess afterlife. Now, among other religions, Hinduism believes in rebirth, so on and so forth. Buddhists don't believe in it. Semitic religions don't believe it. Islam and Christianity or Judaism, they don't believe. These are all practices which vary from place to place. Now, but none of these, all of them say, speak truth, care for the poor. What is that, brother? Sermon on the Mount. Blessed are those who are poor. Is it? Yeah. Sermon on the Mount. Blessed are. Yeah. What is it? What is it conveying? Is it not socialism it's conveying? Yeah. So the point is, taking all these things, that this country is home for all the people of various paths of faith, to synthesize them, to provide a harmonious environment for all these people to live together peacefully, the Constitution was created. Now, we drop it today, well, still the other parts remain, the fundamental rights. Coming to the socialism part of it, Nehruvian socialism, Nehruvian I say because it all started in Karachi with his resolution, which was adopted into the Constitution. Because nowadays it has become another problem. Mention about Nehru is a big problem. Mind you, in my life I never voted Congress party. I'm not campaigning for the party. But you can't distort history. It's how it started. Now, this is exactly what I read it. The state shall own or control key industries and services, mineral resources, railways, waterways, shipping, and other means of public transport. I suppose, Mr. Rajiv, that's also part of the communist theory, isn't it? No, he adopted it there. He was impressed by that and he adopted it. But, as I mentioned today, it's a continuous debate. What he believed is the right way to secure or destroy the poverty and get a prosperous society. What Nehru and his colleagues in that generation believed, that socialism is, because they had seen the Russian Revolution, something good happened, therefore they hoped it would. But this doctrine was abandoned by that very party by 1990. Today everybody is singing the praise of late Mr. Narasimha Rao, incidentally he is a Telugu man, and Mr. Manmohan Singh. What they did is, without deleting the word socialism, they did everything to destroy that concept. And I'm not blaming them. They were live to the reality. The Indian economic situation was that on that day, unless they make a deviation from the doctrine, perhaps the survival of the nation, the amount of indebtedness, national indebtedness, people had to, the government of India had to give, pledge the gold reserves with the International Monetary Fund. So they had to find a solution for the problem. They didn't simply drop the word. They didn't do anything. They quietly did it. They deviated from the socialist path 1990. No, before that, how socialist, those people, all those people who talked about socialism, not at all, that's a lighter wind talk. Broadly, the initial days, there was an attempt to either own or control the resources in this country. But that effort proved over a period of time to be not very beneficial for the overall benefit of who is responsible for it. Is it the planners who are responsible, or is it the people? Why did public sector undertakings fail? It's a matter of great debate. Ultimately, who is running the public sector undertakings? You, me, and your brother, or my brother-in-law, or somebody. These are the people who are sitting there, managed or mismanaged the public sector undertakings. And how is it that the same industry, when it's handed over to some private enterprise or entrepreneur, how is it that it's able to show in the account books profits? These are all great debates that you have to, but these things go on. Human nature is the problem. You have to plan for it. This was discarded long back 1990. No, there is no guarantee, maybe another 20 years later or 30 years later, another wave of change. Well, maybe a more rigid socialistic practice may come into operation. We don't know. We don't know that. We have seen the religious practices. What was considered to be immutable 30 years back, today nobody believes it. Maybe another 30 years, the rate at which things are going, people may start believing it. We don't know, but human nature, we have seen all these things. Human history has enough evidence of all these things. Now, the question is whether it should be dropped. It all depends on the majority in the parliament. If somebody wants to do it, of course, as I mentioned sometime back, the Honorable Minister made a statement, there is no such proposal. Question is not whether they are going to, I told you, without dropping that word, all the old, this requirement of communal control over the state's assets, minerals, so on and so forth was given up. Of course, we had our own, it had its own consequences. We had coal black scam, whatever scam, 2G scam, all kinds of scams came. Well, these things are human beings. We abuse our liberties. So some kind of control is required. It is an ongoing process, ever ongoing process. Now, if a change is sought to be made, of late we hear a lot of talk in this country. Supreme Court was wrong in laying down the principle of basic structure of the Constitution, Keshavananda Bharati case, that the Parliament, being a representative body, it should have the authority to change the Constitution, amend the Constitution, or some call it meddling with the Constitution. Anyway, I'll be more respectful thing. We can change it now. In theory, nobody can dispute it. But question is it a transient majority in the Parliament which enables us to destroy? In fact, this argument was advanced in Goloknath. Goloknath's case, which is later came to be almost ridiculed. Subbarao, who is the author of the judgment. This argument was advanced. If you don't permit amendment of the Constitution, the whole question there also was whether the Parliament had the authority to amend the fundamental rights and so on and so forth. An argument was advanced. If the Supreme Court continues like this, stopping the amendments dealing with property, there would be a revolution in this country, the whole constitution will go. That was an argument, it's recorded, anybody can read the judgment if you have not read it. And Subarao said, there is nothing to choose between destruction by amendment and destruction by the revolution. Both are the same. Question is, do we believe in some basic concepts and basic human liberties? Even those things are now, but after deleting the 42nd Amendment, the fundamental, well, ultimately, members of the Parliament, members of the Legislative Assembly, judges of the constitutional courts, because they have the authority to declare law unconstitutional. All of us are members of the civil society. It's their own maturity level which either preserves or destroys the constitution. Just dropping one word here, introducing another word there is not going to make any difference. So therefore, in substance, this clamor, the heading today's clamor, I think anyway, for the time being it subsided once the minister made a statement. We don't know this can surface again. So let us be aware of why these words are there, whether they should be there or not. It's for us, the people, ultimately we make the nation. We human beings make the nation. It's for us collectively to determine whether we should live in a society which is secular in the true sense of it. We are willing to look at all human beings as human beings. If we are willing to do that, all these problems do not arise. And as lawyers of law, it's our responsibility to tell the society, to as many people as possible, look here, would we like, ultimately one question, would we like to live in a country where you have no freedom of conscience or no freedom of liberty? That's the question ultimately. So it's for us to determine. I think I've taken enough of your time. Thank you.
We are having a short interactive session. If there is anyone who would like to question to Justice Chelameswar, we will just pass around the mic. You can raise your hands. I can see one. There's one here. Yes. Two.
Vice President, reason.
Slightly away. Keep the mic slightly away.
Am I audible? Our former Vice President, Mr. Jagdeep Dhankar, he put up an argument that the preamble of the Constitution should not have been amended because it's not amendable. So I would like to get your view on that.
Dhankar himself is a matter of history today. Why bother about him? No. See, question, the gentleman, I don't know, sir, may I know your name? Prasad. Okay, Mr. Prasad is asking you. It appears the former Vice President made a statement somewhere that the preamble of the Constitution can't be amended. I don't know what basis he made it. I have not heard it, but I'll take it from Mr. Prasad that he said so. And in law, it is exactly the question, what is decided by the Keshavanda Bharati case. Any part of the Constitution can be amended. The only limitation is that in the process, you should not destroy the basic structure of the Constitution. Whether every word in the preamble constitutes the basic structure or not, unfortunately, we are guilty. If not me personally, the Supreme Court. They never defined what is basic structure. They said we'll decide it as and when the question arises every time. But I don't see any legal basis for that. I don't see anything. It could be amended. No. Only thing apparently as a political problem, Mr. Dhankar believes since it was an amendment brought by somebody to whom they are politically opposed, therefore it is wrong. That seems to be the problem. But in law and in theory, in jurisprudence, this is not how things are decided. I don't think there is any problem in amending the preamble. Yes.
Thank you, sir, for giving this opportunity. Thank you, Your Lordship, for giving this opportunity for a tribal community person hailing from Lakshadweep. Actually, we are ruled by constitution, but we have no parliamentary system. Our Punjab and the administrator is appointed by the, not by the President of India. What will be the solution? Not appointed by the President of India. Administrator, President Administrator.
The question is, it appears, you will pardon me for this. Now I have become almost redundant in this country. I stopped reading newspapers quite some time back. I don't buy newspapers. And I don't have a TV at my residence. So information, of course, I am very backward. Now what he tells me is, the President of India is not appointing the administrator for Lakshadweep. So what should be done is the question. Two ways I can answer. One is on the light ravine. Light ravine is that the laissez-faire doctrine is the government that rules the least is the best. If you are no administrator, you are a happy soul. Be happy with it. Why do you want a problem by getting an administrator? That's one thing, but that's not the answer, real answer. See, if the administrator is not getting appointed by the president hardly does anything on his own. He acts only on the advice of the Union Cabinet. Now you put pressure on your local member of the parliament saying that why is it happening? Why don't you go and ask the government? That's the only solution. Or theoretically the solution is you can go to the court and try your luck. I don't want to say anything more than that. You can go to the court seeking a mandamus. These are the two possibilities. Yes, sir.
Sir, can I ask you a question, sir?
Where?
Sir, I'm Advocate Parvati here. I'm an alumnus of this college, and I was teaching here as well. Now, sir, like as far as this, I was hearing the initial speech and the initial word, how to open your which has been undergoing a lot of amendments. Then, for me, as far as I am concerned, whatever I have felt is, sir, like perhaps the makers of the Constitution, because of the nature of our country, go by the pulse of society, come to our preamble is concerned, these people they are more or less perspective. So since we have been country has imbibed an ideological modification of the reality, this not or it is not help the country as a whole. As a people, especially because these people have developed so much by the Supreme Court verdicts, it has become a power system. So at some point in time, think of removing these people maybe as well as distributing the system and also protecting the country as a whole, except any referendum and then take removal of
Your are only making a statement. Broadly, without meaning any disrespect to the lady, she made a huge statement. She didn't really ask a question. She made a huge statement. According to her, any attempt to drop the words socialist and secular from the preamble would amount to the alteration of the basic structure of the Constitution. And she wanted eventually, then I said, what is the question you are asking me? All right, it's your opinion, your opinion. What is your opinion about it? And the reason which she gives for that statement is that whether they were there originally or not, by acquiescence, she wanted my opinion. I don't agree with you, madam. I'll give you the reason. I'm not giving a fatwa. I'll give you the reason. All right, Parliament does not drop these two letters and repeal Article 25 to 30. What happens? Is it permissible? I'm testing the logic of your statement. So, the secularism doesn't depend upon the existence of those two words. Even before those two words were introduced, there are enough provisions in the Constitution which provided for a secular structure of the Constitution. These two words, if they are there or not, okay. If they are there, it feels a little better. Since we have been used to it for the last, without meaning any, I don't think I'm trying to be too silly about it. It's like, there is an old saying in my lingo. There is an old broom in the house. Suddenly one morning it's lost. Well, we feel very, hey, what happened? It's useless. If it goes, we'll buy a new broom. Point is not the broom. The question is how we keep the house clean. See, these provisions, these two letters, these words in the preamble by themselves do not constitute the, it is the body of the Constitution, the ideas behind the Constitution. They are the basic structure. That's my view. You may not agree with me, that's a different matter. I'm entitled for my freedom. Yes, please come.
Sir, good afternoon, sir. Sir, sweetly remembering the moments that you shared with us, the students and staff of Government Law College, Inaugural, during precisely on 22nd November 2018, we had a wonderful crowd there. You had a wonderful...
Acoustics are bad, you talk to me.
You can 22nd November 2018, you had been here.
I know. Well, the adjectives are not necessary. I was here is a fact. Yes.
The basic thing generally viewed that when religious matters which are to be examined in the paradigms of constitutionality, Supreme Court conveniently raises ERP doctrine, that is essential religious practices doctrine, instead of analyzing it under the fundamental rights paradigm. It's a general view. So, will you have anything to offer as your comment?
Yeah. See, the fact that Supreme Court is invoking the doctrine of essential religious practices being beyond the reach of the legislative process. And what is an essential religious practice, we will decide. Well, I can only quote this. Since you are a teacher, academic. Have you seen that commentary on American Constitution by a man called Lawrence Tribe? You saw that. In his preface, he says, I do not consider the judgments of the Supreme Court to be synonymous with constitutional truth. A court which held slaves to be non-persons, Dred Scott. Separate is equal. Massey versus Ferguson, until Brown's case came, this separate but equal doctrine was consistently held by the American Supreme Court to be permissible constitutional practice. He said, could either hardly be final or infallible, but The profundity of the scholarship of the man comes in the next sentence. But such finality, such passing finality, to be more precise, the language, such passing finality as the judgments of the Supreme Court have is essentially a compromise between order and chaos. If the Supreme Court is not there, then we'll have to resolve all these things, take sticks or AK-47, whatever is available, we'll have to solve it. Now, if you don't agree with a particular view expressed by the Supreme Court today, so long as the system exists, there is a hope, if not today, some other day your view will be accepted. All said and done, there are views, your views or my views are views only, depending upon how many people accept these. See, the entire nation, all the 140 crores of people will never have uniform opinion about any issue. Question is the majority view. And those majority is not a transient majority. There are some essential features, what the Supreme Court said, basic features. So long as those views are not inconsistent. Now, what is happening in this country is elected representatives believe, since we got the mandate from the people, whatever we do is right. That is exactly the constitutional issue. That's what is not approved by the Constitution. We don't want this Constitution, throw it out, put it into the Arabian Sea, that's a different matter. I am not on that. So long as this is the system which we have chosen, the legal system is an umpire between these two factors, legislative bodies and the constitutional correctness. It is entrusted to them. You have to accept it. If you don't agree with a particular view, you have to continue fighting, saying that please correct your view. It's possible. What was right in 67 in Golaknath was found to be wrong in 73. It's possible always.
I think we'll take one final question, and because the Honourable Minister also is in a hurry.
Please come here.
Please come very fast, please. We'll take that one final question and call it a day.
Okay, I'll answer. This gentleman, young man, what is your age?
28.
28. Well, naturally, with your age. He says all existing theories and political ideologies are defective. Can we find some perfect ideology? Well, the age is such that the people... Young man, I can only tell you this. There is nothing perfect in the universe. Even the great Einstein's theory is subjected to corrections later. Is the greatest mind produced by humanity, please remember it. Einstein, who discovered the theory of relativity. Even that theory underwent tweaking subsequently. There is nothing like, and particularly in natural sciences, some degree of an approximation of truth is possible, if not the truth. In human sciences, humanities, that's because the variables are too many. 600 crores of people on the face of this earth today. We don't know tomorrow how many it's going to be. And no two human beings think alike, perfectly alike. You have siblings, brothers, sisters? Do all of them share the same idea about everything under the sun? They don't. That's the beauty of humanity. So therefore, to find a perfect system which can satisfy all the 600 crores of people, it's simply mathematically not possible, if not otherwise. But the only thing is, they're all approximations, attempts. You don't give up. We want a better system, therefore, what we believe this would be a better system, we find. See, somebody asked me, why did you hold the press conference? Why are you... I thought things are not right, and I owed a duty to the fellow citizens of this country, which gave me the honor of becoming a Supreme Court judge. So therefore, I thought I should tell them there's something going wrong here. I may be right, I may be wrong. A lot of people criticize me for holding the press conference. I'm not on that. That's the way I choose. So long as I don't resort to violence, well, I can advocate my views. You can also do it.
I think with that we'll come to the end of the interactive session. Thank you very much, sir.
Thank you all.
Now I would like to invite the Honorable Minister for Law and Industries, Mr. P. Rajiv, who is here to speak a few words.
Honorable Justice Chelameswar, Honorable Justice Joseph sir, and dignitaries who are present here. Sorry for not being on time here due to my hectic schedule. And we have two fearless judges with us. Their presence elevated the nature of this function. I was a student here, the 90, 91, 94 batch. And I can proud to say, this is my alma mater.
I am surrounded by friends all around here, therefore I need not fear anything. Your bravery comes out when you are surrounded by adversaries.
But fear is the common nature and character of the Indian society now. That is why I have mentioned like so. This is my alma mater, I can proudly say. Polyam Rose teacher is here. She was my teacher. And Vijayabalam sir was the principal. Bipin Das he is my classmate. We sat together in this classroom. I would like to congratulate Sanjay and team for inviting Justice Chelameswar for delivering this speech. It's a wonderful speech. And Prasad has coined a question, the remarks of the former Vice President, whether amending the preamble is correct or not. The former Vice President could not find to check with the AI. Because if we put a question to AI, then it would give an answer. 42 countries have already amended their preambles, and 8 countries are continuously amending their preamble. But whether it is there or not, secularism is the basic structure of our constitution. But what is happening now? The structure is withering while the skeleton is existing. That is the reality today. And I would not like to more time. These constitutional institutions are transforming. Actually, without amending the constitution, the perverting process of the constitution is happening. Without amending, by changing the administrative mechanism. These constitutional institutions are transforming as an appendix of the executive, like executive legislature or like executive election commission that is happening now. Then we, the people, should stand together to protect our own constitution. Then Ambedkar in his speech gave a warning, that is, when there was no way left for constitutional methods for achieving economic and social objectives, there was a great deal of justification for unconstitutional methods. If there is this constitutional system is existing, then he said, but where a constitutional methods are open, there can be no justification for unconstitutional method. Then whether it is constitutional method or unconstitutional methods to protect our democracy, that depends upon the existence of our constitutional system. I think the lecture is serious conducted by our alumni organization to give more light to those people who believe in democracy, secularism and socialism and our constitution. Thank you.
Thank you, sir. We have a very senior, one of our alumni, Mr. M.C. Wilson, sir, who is a former law secretary. Can we have the Honorable Minister to kindly present a memento to Sri M.C. Wilson, sir?
Thank you, Sanjay. Respected Justice K.M. Joseph, former Judge, Supreme Court of India, Chairman of the Law Lecture Series and presiding dignitary of this historic occasion. Respected Jasti Chelameswar, former Judge of the Honorable Supreme Court of India and the distinguished Speaker of the day. Honorable Mr. P. Rajiv, Minister of Law, Industries and COIR, and more so, our alumnus, esteemed invited dignitaries, learned members of the bar and bench, and my dear teachers, colleagues, and my dear students. It is with immense pride and joy that I rise to offer my felicitations on this momentous occasion, the centennial celebrations of legal education in Kerala and the glorious 150th year of Government Law College Ernakulam. 150 years is not merely a span of time. It is a living testimony to an enduring tradition of legal scholarship, the nurturing of enlightened minds, and the shaping of moral and intellectual conscience of a society. From its humble beginning in 1876, the institution has been a cradle for some of the finest jurists, advocates, legislators, administrators, and leaders who have left an indelible mark on the legal and curriculum of a nation. We are deeply honored today to have amidst us Justice Chelameswar's integrity and commitment to the rule of law has inspired generations. His inaugural lecture at this law undoubtedly enriched our perspectives and set the tone for intellectual journey that this series aspires to undertake. We are equally privileged by the presence of Justice K.M. Joseph, whose judicial pronouncements reflect profound wisdom and whose stewardship of this lecture series lends its exceptional stature. As we stand at this historic milestone, we do so with the gratitude of all who have walked these corridors before us, teachers who have instilled in their students a passion for justice, students who carried forth the flame of learning into every field of public life, and well-wishers who upheld the dignity and relevance of this great institution. On behalf of the Government Law College Ernakulam, I extend my warmest felicitations to everyone associated with the successful conduct of this law lecture series. May it grow into a forum that bridges the world of law with the demands of the justice in a changing society, inspiring dialogue, critical thought, and progressive action. Let this sesquicentennial celebration not merely be a look back at a globe, so a pledge to strive towards a future where legal education continues to be the bedrock of a just, equitable, and democratic society. With these words, I once again convey my heartfelt felicitations to the organizers, guests, and all who are assembled here this day as a landmark in a collective memory. Thank you.
I request our alumni member, Senior Advocate Lakshmi Narayan, to give proposed vote of thanks.
Honorable Justice K.M. Joseph, President of the function, Honorable Jasti Chelameswar, former Judge, Supreme Court of India, and it was our pride when he was the Chief Justice of our court. We used to call the court Majestic Court. That was the great presence of Jasti Chelameswar in the first court of Kerala High Court. Other senior advocates, my friends advocates, the principal in charge, Dr. Minnie Paul, the present and former students of the college. It is extremely, I am delighted to be before this August gathering, especially on the account of the fact that this podium is not new to me. Even though I left 35 years back as a student of the terms, I was chairman of the Law College Union. I had delivered many speeches standing on the same point where I stand now. So the organization, All Students Association, that has decided to have a series of lecture series and for the inauguration as suggested by our dear, we hold KM Joseph sir to that esteem. So our dear sir said that we will begin that with Jasti Chelameswar. So we are very happy to see that His Lordship has come over here and delivered the inaugural lecture here on the very relevant topic, aspect of secularism, socialism, whether it should be in the preamble. At the bottom of my heart, on behalf of the All Students Association of this great college, I express my gratitude. I thank you, sir, for your enlightening speech on the topic. I also thank Justice KM Joseph for presiding over the function as well as delivering on the topic, delivering a very short but very thought-provoking speech on the speech. I thank you, sir, on behalf of the All Students Association. I also thank Honorable Minister for Law, Sri P. Rajiv, for his graceful presence and speech. I also thank Dr. Minnie Paul, the principal in charge, for this function as well as the other functions which will be followed. I also thank the former students as well as the present students and all the faculty, and I great respect the honor.
May I request Joseph sir to hand over a memento on behalf of the association. Thank you, sir. Thank you.